Good afternoon, Michiganders. It is Tuesday, November 10. And this, of course, is Tuesday with Tom, Michigan's only weekly internet show where we do answer your questions about estate planning and estate settlement in Michigan, and we don't send you a bill for the answers. I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, and ambassador for all things good in this great state of Michigan. Welcome, welcome, welcome to today's program, November 10. Can you believe the absolutely gorgeous weather that we have been having over the past few days? And if you haven't been outside, make sure you get outside today because it looks like fall weather. What is thought of fall weather is going to be returning soon. In last week's episode, I talked about our estate planning from home service, and given what's going on with COVID right now, and if you look at the news today, which I looked at just this morning before coming on air, Michigan is now the number one state for the increasing rate of COVID and the increasing death rate of COVID. Amanda and I are so happy to offer our estate planning from home service so that you can get your estate plan put together or amended or updated so that you don't have to leave your home. I know it's a little bit different way of doing things, but given today's COVID situation, we really are discouraging clients from coming out and coming into an office setting, and that's why we've put together our estate planning from home service. So take a look at our office estate planning from home service. It's available at doylelawpc.com. If you're an existing Doyle Law PC client, then we have, as you probably know, our Update My Plan service. Again, the ability to have your estate plan updated without having to risk physically coming into the Lansing office, and that service information on it, again, is available at doylelawpc.com. Today's show, and I sent an email out to folks about this, so hopefully you got it, how April 2003, October 2012, and January 2019 might affect your estate plan. We're talking about dates now, and we're talking about estate planning documents that have been prepared prior to these dates. So if you have any estate planning documents, perhaps a trust, perhaps powers of attorney or healthcare powers of attorney that were prepared before any of these dates that I'm going to talk about, it's important to you that you have your documents updated. Again, the dates: April 2003, October 2012, and January 2019. So let's go through them. April 2003 is when the HIPAA privacy rules became effective. And I'm sure you're all familiar with the HIPAA. That's the federal statute and the federal rules that were developed that concern releasing your private medical information by your medical providers. The point of the rules was to limit and to limit disclosure and protect us from disclosing or having our medical providers disclose that information. But there are unintended consequences for estate plans that were prepared certainly before that date. A trust normally has language in it that says a successor trustee takes over managing the trust in the event of your incapacity. A durable power of attorney that would be for finances oftentimes has language in it that it only becomes effective upon your becoming incapacitated. And certainly a healthcare power of attorney or a patient advocate designation only becomes effective if you are incapacitated. So those three documents, the trust, the durable power of attorney, and the healthcare power of attorney, it can be important for your fiduciary, that would be your successor trustee or your agent in the documents, to know if you are incapacitated. The problem that HIPAA has caused is when your agent goes to the doctor and says, "Doctor, is this person incapacitated? I need to know that, so I need to determine if I'm to take over managing their finances or managing their trust or making their medical decisions." Many doctors, many hospitals, many medical providers are unwilling to provide that information unless your trust or durable power or healthcare power is HIPAA compliant, meaning what? That it contains language authorizing a medical provider to, in fact, give that information to your successor trustee or to your agent under the durable power or the healthcare power. So if your trust, healthcare power, durable power were prepared before the privacy rules even came into effect, most likely there is not an authorization in those documents for the medical provider to provide that information. I know in our office, any of those documents that were prepared after the privacy rules became effective, we automatically include those authorizations. So what do you do if your document was done before 2003 and or does not have those authorizations that are required to be in them for your medical provider? Well, one, you could certainly have new documents prepared. New documents, certainly, that we would be preparing, again, would be HIPAA compliant. So if you're going to have a new trust or a new durable power or a new healthcare power of attorney, and we prepared them for you, they will already be HIPAA compliant. Another option that some clients go for, maybe they don't have a reason to have a new trust prepared or new durable power, new healthcare power of attorney, is to have what's called a HIPAA authorization prepared, a separate document that you execute in which you authorize medical providers not to provide all of your medical information, but to provide the amount of medical information that's necessary for your successor trustee or your agent under your durable power or your agent under your healthcare power to determine if you are incapacitated so that they can do what it is you ask them to do. That's our first date, April 2003. That, again, is when the HIPAA privacy rules became effective. Our next date, October 2012, and this has to do with durable powers of attorney. As you know, durable power of attorney is a document in which you designate someone to manage your financial affairs for you. As of October 2012, the state of Michigan, a revision to the statute, requires that a durable power of attorney has a section in it, which is commonly called an acknowledgement of responsibilities, where the person that you are naming in the document to serve as your agent signs it, in which they agree to what their responsibilities are, and they understand and acknowledge what the limitations are on their authority. Now, if you have a healthcare power of attorney, you likely are familiar with that. At the end of that document, there is a place in your healthcare power of attorney for the person that you name to make medical decisions to sign it, and it basically sets out what the limitations are on their authority and what kinds of things they are responsible for. Similar documentation is now required as of October 2012 in a durable power of attorney. If you have a durable power of attorney that was then prepared before October 2012, it is likely that it does not have an acknowledgement of responsibilities because there was no law requiring it. And certainly in our office and many others, there was no section in a durable power of attorney. But after October 2012, certainly powers of attorney that our office is preparing, we automatically include the acknowledgement of responsibilities. What's happened since October 2012 is that old durable powers of attorney, now let's be clear, the law didn't say old durable power of attorneys are no longer effective, but what has happened is since October 2012, banks, credit unions, financial institutions have been refusing to accept durable powers of attorney without an acknowledgement of responsibilities attached to it. There is a fix, though. One, if for any reason you're going to have a new durable power of attorney prepared for you, certainly our office, the new durable powers of attorney, again, that we prepared today, have acknowledgement of responsibility sections in them. Older durable powers of attorney, maybe there's not a reason to change your durable power of attorney other than to make it comply with the law. There is the ability to add an acknowledgement of responsibilities to it, and then to make sure that it gets signed and dated by your agents. Again, two solutions that are certainly available through us to make sure that your power of attorney that was prepared before October 2012 is going to be accepted and recognized when the time comes for it to be used. Our third date, January 2019. January 2019 is when Michigan's new statute became effective on certificates of trust. And I've had previous episodes of this program, again, about certificate of trust, and perhaps you need to have a new certificate of trust prepared for you. Before January 2019, there was no statute in the state of Michigan that defined what a certificate of trust relative to a trust agreement had to contain. We would prepare certificates of trust, and it would be used as a funding tool. It was a summary of your trust. So when you went to the bank and wanted to either put your bank account in the name of your trust or perhaps make the trust a beneficiary, it had the information that the bank would need to determine who was your trustee, what was the date of the trust, and particular information about the trust without the necessity of giving the bank a copy of your entire trust document. At that same time, before January 2019, there was a different document. It was called a Certificate of Trust Existence, and that was a document that title companies required if a trust owned real estate and wanted to sell it. It required a Certificate of Trust Existence that had its own statutory requirements in order to complete the sale so that it could be recorded. Well, in January 2019, the state of Michigan new statute came into effect that combined both of those documents into one certificate of trust. And so that statute now says what a certificate of trust has to contain, whether it's a certificate of trust that's being used for funding a trust, i.e. when you go to that same bank and you want to put a bank account in the name of your trust, or you want to put a life insurance policy beneficiary, or you want some financial services institution to do something relative to your account and perhaps put it into your trust or fund it to your trust. That new statute now says what it has to require, what it has to contain. And since January 2019, if your certificate of trust doesn't meet those current statutory requirements, you will find that your banks and your credit unions and your financial organizations, etc., are not going to be willing to accept the certificate of trust, nor is a title company going to be able or willing to accept a certificate of trust that does not comply with those new statutory requirements. And there's a few. Some of the requirements, it has to have the name and date that the trust you're created. It has to have the date of what it refers to as each operative trust amendment. So if you ever amended your trust, that has to be reflected in your certificate of trust. It has to contain the name and address of the current trustee. So if it's being created while you are alive and serving as trustee of your trust, the certificate of trust would have your name and address. Once you die and there's a successor trustee who takes over, now that certificate of trust is going to have the name of the trustee who is then serving. It has to indicate the powers of the trustee relative to the purposes for which the certificate is being prepared. It has to indicate whether or not your trust is revocable or irrevocable. If you've got co-trustees, which sometimes clients have co-trustees in their trust, it has to indicate whether or not they can act independently of each other or they have to act together. And certainly if it's going to be used for real estate, it has to contain a legal description of real estate to which it applies. Now, where these are frequently coming up in our practice today is when someone comes and wants to sell real estate. We're getting phone calls, we're getting emails, we're getting contacted through our website. Hey, I've got real estate. I'm trying to sell the real estate. The title company is now requiring an updated certificate of trust. Can you help us? Well, yes, we can. The way to handle it is to have a new certificate of trust prepared for you. You can't fix an old one. You simply have a new certificate of trust. It's the only fix that's available to take care of that problem. So, again, important dates. April 2003, that's when HIPAA privacy rules came into effect. October 2012, that's when durable powers of attorney now required acknowledgement of responsibilities. And January 2019, when the new statute became effective relative to certificates of trust. If you have any documents that are prepared before those dates or in between those dates, if you have a trust or a durable power of attorney or healthcare that was prepared before April 2003, or you have a durable power of attorney prepared before October 2012, or you have a trust that was prepared before January 2019, it is likely that your documents need to be updated, need to be reviewed to make a determination of what is required in order to bring them to be current. Certainly something that Amanda and I are able to help you out with. If you're an existing client, again, go to the website, go to the Update My Plan feature under the virtual office. Tell us what documents you're looking at that you're concerned about. We'll review them at our end and determine what else needs to be done in order to make those documents compliant with these changes in the law. If you're a new client, you can always shoot us an email at info@doylelawpc.com. Tell us what the age of your document is and what your concern is, and we'll let you know what you're going to need to do in order to update your plan. Again, Amanda and I would be honored to have the opportunity to help you protect your loved ones and your family with either creating an estate plan for you, amending an estate plan, or settling an estate. Again, all of that's available through our office, through our virtual office, where you're not going to have to risk your health. Simply contact or go to the website, doylelawpc.com. Look at how those services can be provided to you, or you can always call the office, 517-323-7366, and we'll work on getting a telephone consultation scheduled for you. Well, that's it for today's show. As always, if you have a comment about our program, a topic that you would like to have me discuss, or questions that you'd like to have answered, please send me an email, tom@tuesdaywithtom.com, or mail me a postcard, Tom Doyle, P.O. Box 16066, Lansing, Michigan 48901. As always, we invite you to follow us on Facebook and Twitter. That's going to be Tuesday with Tom. Follow the office as well at Doyle Law PC. Remember, too, the Tuesday with Tom app is available in both the App Store and on Google Play. And as I announced before, not only is the program available on Apple Podcasts, but now it's available on Spotify, it's available on Google Podcast, and you can always ask your smart speaker to play Tuesday with Tom. Thanks again for spending some of your time with us today, and as always, I hope that you have an awesome day and an awesome week in Michigan. Stay safe. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.